as Mr. Dickson probably told you, I live in Harwich, so I have a special kinship to the school and the community because I don't live about maybe 3/4 of a mile as the crow flies from here. So I'm very pleased that we have such a great program for you, and that Mr. Dickson, who's so committed to government and teaching you about government and the law, which I don't think there's enough of, quite frankly, in high schools. This is a really great class and a great opportunity for you to get a glimpse, a little bit of a glimpse into what goes on right up on Route 6A in Barnstable Village. Maybe you've never been there, which is a good thing if you haven't. There's only 3 courts on the Cape that we have. We have Orleans District Court, which is our jurisdiction for Harwich. We have the Falmouth District Court, which takes care of the Upper Cape. And then we have Barnstable District right in Barnstable Village. And we only have 1 Superior Court, which is where I sit, in the Barnstable Superior Court. And hopefully you'll never ever go there because that's where the major felonies are tried and people who are serious offenders are prosecuted and defended in that court. In any event, I have the pleasure of sitting there, and I have for the last 8 years, and I have a whole host of folks who come before me at that court, and these 2 regularly come before me are 2 excellent professionals in their own right. Assistant District Attorney Ned Lynch was a defense attorney, and as a lawyer you have to be able to take on and off the hats that we all are asked to do as lawyers, because a lawyer sometimes will represent the prosecution, sometimes will represent the defense, sometimes will represent the plaintiff, the moving party in a civil case, sometimes will represent the defendant, and vice versa. And then defense attorney Hofmann, who works for the Committee for Counsel for Public Services, has a huge caseload and defends folks who are not able to retain their own attorney, but yet is in the Superior Court, which is the higher echelon of defense attorneys, and he regularly appears before me and will next month because I'm sitting criminally alternate months. So that's what we do up at the court. So what we want to do today is give you a glimpse, just a little tiny glimpse, of what's called a pretrial hearing, because every case starts with a police encounter where the people who wear the badges, men and women, are out there to enforce the laws of our Commonwealth, and they have a certain understanding and level of knowledge of the law. And then once they do what they do in terms of enforcing the law and someone's placed under arrest, that's when the attorneys go to work and figure out whether or not the circumstances of the arrest are sufficient within the bounds of various constitutional principles. And today we're going to talk about the 4th Amendment, which is the right of all of us to be free and secure from what's called unreasonable searches, unreasonable being the key word. And the reasonableness of a search and the amount of intrusion is on this scale of justice balancing act that we do each and every day in the court to determine, and this is all interpreted by case law, whether or not the 4th Amendment has been adhered to or not. So if the 4th Amendment has not been adhered to, then the judge, in this case me, has to make a determination that the evidence that might have been seized or taken, or a statement that was taken from a defendant, was unconstitutionally impermissible, therefore it should be excluded. So the Commonwealth is seeking to, if you will, support the police effort in terms of seizure of evidence and then going forward with prosecution, and the defense is trying to keep it out because if the motion to suppress is allowed, that means the evidence is suppressed. Just what the word means, it doesn't come in. If the motion to suppress is denied, then of course the evidence can come in. So what we do each and every day is we balance the rights that we all have, and this is guaranteed under the Constitution, right? You know about the 4th Amendment, you've studied it, right? And we balance the 4th Amendment rights that we have against our responsibilities as citizens to abide by laws that we, as the people, have said, as a law-abiding citizenry, we wish to abide by. So, for example, in this particular scenario you're going to hear about is an attempt to seize incriminating evidence as a result of a motor vehicle stop. So motor vehicle stops have a certain status under the 4th Amendment as to when the police, because of the exigency of the circumstances, and exigency meaning emergency. The emergency of the situation permits them a little greater latitude because they're out on the street, as opposed to in a more confined setting like someone's house or workplace or another encounter. But we'll get into that. So I don't want to take too much time talking myself, but I want to just to give you the backdrop. So we're going to try to go through a little role play. Mr. Dickson's going to be the police officer, who would normally be Officer Davis. So he's going to take the witness stand. He's going to be sworn in by the clerk of the court. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth during the course of these proceedings?
I do.
Okay, he's going to take his seat right where he's sworn in. So the officer comes in, he takes his seat on the witness stand. I'm up there listening and watching what's going on, and I'll say to the Commonwealth, ADA Lynch, do you wish to introduce any evidence in support of the Commonwealth's motion?
I do, Judge.
Sir, could you state your full name and spell your last name for the record?
John Theodore Dickson, D-I-C-K-S-O-N.
And who are you employed by?
I'm employed by the Harwich Police Department.
In what capacity?
I am a detective in the Harwich Police Department.
For how long?
I have been a detective for 8 years and an officer for 20 years.
Drawing your attention to the past Saturday night, early morning hours, were you working that morning?
I was indeed.
What duty were you assigned?
I was assigned a circuit of mostly East Harwich.
And at approximately 12:30 in the morning, did you have an opportunity to be patrolling the East Harwich area?
I did indeed.
And what type of patrol car were you using?
I was using the standard Harwich Police Tour, the Crown Vic.
Okay. And is it a marked cruiser or is it unmarked?
Yes, a marked cruiser, yes.
And what were you wearing? Were you wearing a uniform?
I was indeed in uniform, yes.
Okay. And did you have a firearm?
I did have a firearm.
Now, at approximately 12:30 in the morning, did you observe something?
I did. I observed. I was on the side of a road doing some trapping, some speed work, and I did observe a car pass me with 5 young people in it, and there was a broken taillight on that vehicle.
Now, what road was this?
This was on Route 39.
Is this a road that's maintained by the town?
Yes, indeed.
And when you made that observation of that taillight, what did you do?
I entered traffic behind them. I put my emergency lights on and behind the car, and with the intent to have them pull over, and they did indeed pull over.
And so how far up the road did they pull over?
Maybe 200 or 300 yards.
And when you saw the motor vehicle stop, where did you position your cruiser?
I positioned my cruiser. They were completely off the roadway on a grassy surface. I placed my cruiser with maybe a third of the vehicle still in the roadway.
And did you have your takedown light illuminated?
Yes, I did.
So you could see the cruiser or the motor vehicle in front of you?
Absolutely.
And at some point in time, did you approach the car?
I did.
Prior to approaching the motor vehicle, did you make any observations of the individuals inside the car?
Yes, indeed. The individuals in the car, there were 5 individuals in the car, so there were 2 in the front seat and 3 in the back seat. And the individuals in the back seat were moving a lot, kind of ducking up and down, moving side to side. And so I was alerted to that activity.
So at that stage, did you call for backup?
I did call for backup, and backup arrived, I think, within 2 or 3 minutes.
And when backup arrived, what did you do?
At that point, I approached the vehicle on the driver's side. The driver rolled his window down, and I asked for license and registration. The driver provided me with a license and registration.
So having received that license and registration, did you return to your cruiser?
I did indeed.
For what purpose?
I did in order to enter the name on the license into the database to see if there were any warrants out for this individual, and to prepare a ticket or a citation for the taillight.
Now, again, this is 12:30 in the morning.
Mm-hmm.
And at that stage, when you're processing this information, did you make further observations of the back of the motor vehicle?
Yeah, at this point there were continued movements, and this became, I found particularly suspicious, the continued movements in the back seat.
Okay. And again, where were the individuals that were inside the motor vehicle positioned?
There were 3 in the back seat across, and 2 one in the passenger side and 1 on the driver's side.
And were they male, female?
They were all male.
And after you made this observation, after you processed the information concerning the license and registration, did you approach the motor vehicle again?
I did approach the vehicle a second time after observing it.
What happened then?
At this point, I asked all the occupants of the vehicle to leave the vehicle, and at this, I also had the second officer, Officer Davis, come up with me, and all 5 then did exit the vehicle.
Right, and when the individuals exited the motor vehicle, where did you put them?
We had them all on the, behind the car, on the road, so they wouldn't be on the roadside, but they all, on the roadside, we asked them to put their hands on the vehicle, and we proceeded to pat them down.
And so this was an area between your cruiser and the motor vehicle itself,
Yes,
right?
yes.
And when you say you patted them down, describe what you did.
I used Officer Davis and I, each two people at a time, patted down their arms, the outside of their clothing, their lower leg. But we were looking to see if any of them had a weapon on them.
Okay. And did you recover any weapon?
We did not recover a weapon, but there was a large a bulge in the outer pocket on the driver, and in investigating that, it turned out to be a roll of money.
Now, you indicated earlier that you observed movement inside the motor vehicle. What area of the motor vehicle did you observe the movement?
It was the rear seat again. It was the same movement as before, and in my experience, that is consistent with people who may have a weapon in the vehicle, and that would be
Sustained.
Well, at some point in time, did you also search the motor vehicle?
Yes, we did search the motor vehicle.
For what purpose?
We searched the motor vehicle to see if there was a weapon in the vehicle.
So describe what you did.
I think Officer Davis did the front seat, searched the front seat. I searched, actually, I'm sorry, let me correct that. Officer Davis maintained observation on the 5 individuals outside the vehicle, while I searched first the back seat and then the front seat of the vehicle. And I was searching underneath cushions in the sort of area between the back of the seat and the seat itself, and as well as on the floor.
And when you were making this search, did you find something?
Yeah, indeed, we did find a bottle of vodka that was opened, mostly full, in the back seat on the floor.
Now, did you have a conversation with the 5 occupants concerning this bottle of vodka?
We did indeed. We asked whose bottle of vodka this was, and none of them claimed that it was their bottle of vodka.
By the way, by this time, have you also understood who these individuals were, their names, their dates of birth?
Yes, and I apologize that I missed that. That when we first asked them out of the vehicle, we also asked them for identification, which they all provided. So we did have all their names.
So was there an understanding that these individuals were underage as far as?
They were all 17 and 18.
And again, you asked them whether or not any of them owned this bottle of alcohol?
Indeed.
And what did they say?
They all said, no, it's not mine, essentially, or words to that effect.
Now, after that process, was there some further search done of the motor vehicle?
Yes, at that point, we asked we told the driver to open the trunk of the vehicle, and he proceeded to do so, and in searching the trunk of the vehicle, we found an amount of marijuana.
And where was that found in the trunk?
It was found essentially in the center part of in the open part of the trunk of the vehicle.
Was it in a container or was it out in the open?
It was in a bag, in a paper bag.
What type of bag?
Plastic bags inside a paper bag, I'm sorry.
Okay. So
A brown paper bag.
when you searched the trunk, you opened the bag and looked inside and made
Yeah.
observations?
Indeed.
You secured that item as well?
We did.
Now, was there anything done with regards to the operator of the motor vehicle?
We, at that point, having found alcohol present, I asked the driver of the vehicle to, well, we didn't ask, I'm sorry, we put the driver vehicle through a field sobriety test.
Okay, so let me take a step back.
Yeah.
The item that was found in the trunk, the marijuana, was that subsequently weighed?
It was later weighed, yes.
And was there a determination as to the weight of that item?
It was approximately 2 ounces.
Now, you described a second ago that there was a field sobriety test done?
Yes.
Can you describe briefly what that was?
Again, Officer Davis being maintaining observation of the other individuals, I used an eye tracking test. I used a walking a straight line test, a finger to the nose, alternating fingers to the nose test, and in my estimation, the driver failed that sobriety test.
So, as a result of that actual test, was this operator charged with operating under the influence?
Yes, the operator was taken. He was ultimately charged at the station. The driver did submit to a breathalyzer test.
And what was the result of that test?
0.03.
Now, with regards to the 4 other individuals that were inside the motor vehicle, were they charged?
They were all charged as minors in possession of alcohol.
And again, the driver was charged with OUI. Was he charged with anything else?
Yeah, he was also charged with possession of marijuana with intent to distribute.
There's nothing further.
All right, Attorney Hoffman, cross-examination.
Thank you, Your Honor. Good afternoon, officer.
Good afternoon, Mr. Hoffman.
You mentioned that at around 12:30 that morning you were in East Harwich?
Yes.
On the side of the road?
Yes,
You saw a car with young people in it drive by?
yes,
And you mentioned that there was a broken taillight on the car, right?
yes indeed.
Right after you saw that broken taillight, you pulled in behind these young people in the car, right?
Yep,
And you activated your lights,
yes,
and they slowed down appropriately, didn't they?
they did,
And they pulled right over to the side of the road safely.
indeed.
And in fact, you stated that it was between 200 and 300 yards maybe that they traveled.
Yeah.
You didn't see any kind of erratic driving, did you?
I did not witness in those few hundred yards, yeah, I did not witness any erratic driving.
In fact, you didn't notice anything about the car at all until you saw the taillight.
Well, I certainly noticed the vehicle approaching. The vehicle was not speeding, but no, I did not notice any erratic driving to the approach.
Now, you mentioned that after you pulled the car over, you saw the backseat passengers ducking up and down and moving side to side, right?
Yes.
And it's hard for us to imagine what you mean exactly by ducking up and down and side to side. So I'm going to ask you, is the type of motion that would be consistent with maybe buckling or unbuckling the seatbelt?
It could be consistent with buckling and unbuckling a seatbelt, and when I did approach them the first time, their seatbelts were buckled.
And it's a law in Massachusetts when you're a passenger in a motor vehicle, you have to have a seatbelt buckled, isn't it?
All right, sustain it. Next question.
You called for backup after you pulled them over?
Yes, I did,
And you called for backup before you approached the car, right?
indeed, and backup arrived before I approached them.
And you mentioned that you were carrying a firearm,
Yes,
and Officer Davis, you said when he came, you didn't get into that. Was he carrying a firearm as well?
he was carrying firearms as well.
And then you went up and you approached the car, right?
Yes,
And you determined that there were 5 young people in the car.
yes,
Later determined that they were between the ages of 17 and 18, right?
yes.
And while you were at the car, they were polite and cooperative, weren't they?
They were,
And when you asked for the license, you got the license, right?
indeed,
Same with the registration?
indeed.
No fumbling around, no dropping of the license or the registration by the driver, right? You just got them and handed them to you, right?
Indeed.
You returned to the car at that point. Now, there's 2 officers on the scene, right?
Yes,
And both carrying firearms.
yes,
You mentioned you've been a Harwich police officer for somewhere in the neighborhood of 20 years, right?
yes,
And were these young people from Harwich?
they were.
Do you know these young people at all?
I indirectly, I think I knew one of them. I didn't know most.
Okay. And so you returned to the car to write out the ticket, and you say you see some more movement in the back seat,
Yeah,
and you called that movement suspicious, right?
yes,
So at that point, you made up your mind that you're gonna get them out of the car when you go back up there.
we did. We determined we were going to search them.
Okay. When you did get them out of the car, you brought them to the back, and
Mhm.
there's 5 of them,
5
2 of you,
Yep,
and you patted them all down for weapons, right?
yes.
You didn't find any weapons on them, did you?
Did not find any weapons.
And they were cooperative during the search?
They were cooperative.
And at that point, you had no reason to suspect that the driver of the car might be impaired, right?
At that point, we did not have suspicion of his impairment.
Okay. So after you patted them down and discovered that there were no weapons, you did not allow them to get back in the car, is that right?
We did not allow them to get in the car prior to our searching.
So you decided that you were gonna then search the car at that point,
Yes,
and you did.
yes,
That's when you found a bottle of alcohol?
yes.
None of these young people would admit that they owned the alcohol, right?
Correct.
Incidentally, who owned the motor vehicle?
The driver, it was registered to the parents of the driver.
You have no reason to believe the parents who own that car are under the age of 21, do you?
Objection, Judge.
Overruled, he can answer.
I have no reason to believe the parents of the driver are under 21.
And at that point, that you discovered that alcohol, you didn't begin to administer field sobriety tests on the operator duty.
It was soon after discovering the alcohol that we did administer a field sobriety test.
Well, my question is, before before you made the decision to administer the field sobriety tests, you went further in your investigation, didn't you?
We did. We continued the investigation, and now we did indeed search the trunk prior to administering field sobriety.
And you mentioned that you asked permission of the driver of the vehicle to search the trunk of the car. Right?
I did not ask permission. I told him we were going to search the vehicle, and we were going to search the trunk, and I asked him to open that so we wouldn't have to use an alternative method.
Because it was locked, right?
Yes, indeed.
And then you found the marijuana,
Mm-hmm.
and then you administered the field sobriety test to the driver?
Yes.
And in your opinion, he didn't pass these field sobriety tests, right?
No, he did not.
Did you administer field sobriety tests to any of the other individuals?
We did not administer field sobriety tests for the other.
Did you have any reason to believe that any of those other individuals may have been impaired?
Yes, we had the suspicion that they would have been impaired, but we did not administer field sobriety tests.
And that suspicion, based on your testimony, would be limited to the fact that there was a bottle of vodka in the car, right?
Indeed, yeah, a partially consumed bottle of vodka.
They weren't falling down?
They were not falling.
And in fact, you were right up close to them when you searched them, right?
Mhm.
And you didn't notice any odor of alcohol or anything about any of them? did you?
There was no particularly noticeable odor of alcohol.
Thank you. I have no further questions.
All right, anything else, ADA Lynch?
No, Judge.
All right, you can step down, officer, thank you. All right, ADA Lynch, do you wish to be heard?
Sure.
Judge, on behalf of the Commonwealth, I would suggest that the officer's actions were appropriate and properly justified, having all authority to do the things that he did that evening in securing the motor vehicle, searching the motor vehicle, searching the persons, and recovering the items that were recovered, and then ultimately arresting the individuals that were involved. Specifically, I would suggest that with regards to the motor vehicle stop, on that particular night when the officer initiated his lights, there was clearly a civil violation occurring with regards to the motor vehicle, that there was a broken taillight. The officer was certainly within his right at that point in time to make a routine motor vehicle stop of that motor vehicle. When the officer stopped the motor vehicle before approaching the motor vehicle, he made observations of movement in the back area of the motor vehicle, and then once he secured license and registration and was processing that information, he made observations of further movement in the back side of the motor vehicle, in the area where there were passengers seated in the back seat. Respectfully, I would suggest that at that point in time there was sufficient evidence before the court, specific and articulable facts, suggesting that perhaps the officer had a valid concern for his safety. And at that stage in this process, the officer certainly was within his right to remove the occupants of the motor vehicle. Having done that, he did search the individuals that were involved, did search their persons. At one point in time, from one person, he secured a $400 roll of bills and secured that as evidence. Certainly, after having searched the individuals outside the motor vehicle, it was prudent and appropriate for the officer also to search the area in the motor vehicle where the persons were seated. I would suggest to the court that the case law suggests that a pat frisk for the safety of the officers under Commonwealth versus Gonzalez could certainly be extended to the area in the motor vehicle where those individuals were seated. It wouldn't make sense, certainly, that an officer would have the right to search the persons outside the motor vehicle and then put them back in the area where there might have been a weapon secreted. So respectfully, I would suggest that once they were removed from the motor vehicle, the officer had the right to search the back seat area. In doing that, the officer did recover a bottle of alcohol. He also had information at that point in time that all the occupants of the motor vehicle were underage. I would suggest at that point in time the officer had probable cause to search the entire motor vehicle, including the trunk and any containers therein. I would suggest that the probable cause that was established allowed him to go to that next step, open that trunk, look inside that bag, and secure the marijuana. The marijuana being over an ounce, he certainly secured that on his person. Based on the observations he made, certainly within his right to submit the driver to field sobriety tests, and based on the fact that the operator failed those tests out in the field, the officer certainly had the right to arrest that individual as well. Understanding all that, Judge, appropriately, the individuals that were inside the motor vehicle in an area where they all had, we would suggest, knowledge of the item that was in the backseat and dominion and control of the backseat, the officer was proper in charging them with all possession of the alcohol that was in the backseat, as to the driver properly charged with OUI, and with regards to the items that were found in the back trunk, certainly driver in control of the motor vehicle should be charged with possession of marijuana. And based on the fact that it was over an ounce, plus the fact that money was found inside the motor vehicle, we would suggest that the charge of possession of marijuana with an intent to distribute was proper as well. So we would ask the court to deny the defense motion to suppress the evidence.
My question is, the Commonwealth proceeding on a joint venture theory with respect to the passengers in the motor vehicle?
The Commonwealth would suggest that in this particular case, that once the item was found in the motor vehicle, the Commonwealth has met its burden in suggesting that all the individuals in the motor vehicle, although the item was not found on their person, has a right to suggest to a trier of fact during a trial that all individuals knew that the items were there, all individuals exercised some dominion and control over the items. So respectfully, Judge, I would suggest that all items, as a result of that, all individuals constructively possessed the items that were inside the motor vehicle.
All right. Attorney Hoffman, you wish to be heard.
Thank you, Your Honor. Respectfully, couldn't disagree more with the Commonwealth's position in this point, Judge. This is a routine traffic stop. Some young people are pulled over for a broken taillight. The officer testified that after pulling them over, he called for backup. Backup arrived. There are 2 armed police officers here, and as they approached the car, they realized there were 5 17 or 18-year-old kids in the car. The officer testified that he knew one of them. At that point, the young people in the car were cooperative. They paid attention to the officer. They did everything asked of him. Nothing suspicious was going on whatsoever. The officer then testified that he went back and wrote out a ticket. While doing so, he saw a little bit more movement in the back of the car. I think it's important to note that the officer does not say anything. None of his testimony leads anybody to believe that he had any reason to fear for his safety. In fact, he described the movement not as furtive, but as suspicious, and that he and the other officer then determined that they were going to search these individuals. I would suggest, Judge, that at that point, the officers had no right to search, no right to remove these young people from this car to search them at all. The officers should have returned to the car, presented the operator with a ticket, and sent them all on their way. Even assuming that they did have a legitimate fear for safety, if they brought these kids out of the car, pat frisked them, and found no weapons, that is the end of the story. There's no further need for fear of safety. They're going to have these individuals get back in the car with ticket in hand and drive away. There's no reason to believe at all that there would be any weapon hidden. There is absolutely no probable cause for a search of the car. Anything beyond, any suspicion or probable cause that arises beyond that pat frisk is based upon a bottle of alcohol that was found in the car only after the pat frisk was done and nothing incriminating or dangerous was found. I ask that you allow the motion.
All right. Well, let's freeze frame this and stop right here, and I want to get you involved because I know you're all experts in constitutional law and you studied this, and there's been a lot of buzzwords, and you can see how fast ADA Lynch can talk and how fast Attorney Hofmann can rebut. But that's pretty much, and we did it really fast, what I have to deal with almost on a daily basis as part of these pretrial motions to test the constitutional sufficiency of evidence that's obtained by the police out on the street as they're doing their job. So let's break it down. What do we have? We have a motor vehicle stop, right? So they're out in the street, police are doing their jobs, and we have something that's going to, if you will, precipitate the stop. What is it? The broken tail light. So there are laws out there that suggest that a civil infraction such as a broken tail light, because it's a public safety concern, if cars have a tail light out or a headlight out, it's a concern for the general public so that we can see what's coming at us or going by us at night. So the police have this sort of community caretaking function of letting us all know, because we don't normally routinely inspect our cars every time we get in them and drive off, to let us know that the tail light's out. So that's what all this officer was doing, right?
Yeah.
So far, so good. Okay. So the stop occurs, and we don't have a real test. There's nothing, this is not math. This is not science. This is really a case-by-case breakdown of facts that I have to find, both in terms of making a credibility determination with respect to the officer. And I found the officer to be extremely credible, didn't you? Oh, yeah. Okay, your grade's sort of depending upon the answer on this. Okay. But he was credible, and he had a good command of the facts, and it seemed like, you know, his answers were forthcoming. He didn't melt or break on cross-examination, but Attorney Hofmann was trying to get out a couple of points on his side, which I'll get to in a moment. But what we have is this balancing act that I talked to you about before, because the law presumes that if the search takes place without the benefit of a warrant. What's a warrant, by the way? Anybody know what a warrant is? Search warrant? This is right.
You know what a warrant is.
Sure. A search warrant is usually gained in advance of a search, where not usually, it always is, where the police, based on what they feel is specific facts and circumstances giving rise to what's called probable cause, can apply to a judge or a clerk magistrate after hours, and we give the little blessing to the fact that the search can take place. Sometimes it occurs, for example, where the police suspect that there's illegal drugs inside of a house, and they want to be able to get in and get them, but of course there's a certain emergency to that because I don't want the drugs to disappear, either down the house plumbing or anyplace else. So there's all kinds of scenarios where search warrants are given that weren't given in this particular case because the officer, of course, didn't know he was going to encounter these folks in the car on Route 39 just down the street. So my point is that we have to take the facts and circumstances case by case, and we look to case law for some guidance. So we have an appeals court and a Supreme Judicial Court, and the judges there are much smarter than me, and they write opinions based on facts and circumstances that are sometimes close and similar to what I have to deal with. They're not always, quote, on point, but the attorneys use them. You saw ADA Lynch had some cases up here, and I have the cases, and Attorney Hofmann has the cases. And this particular case happens to be a case that came down in 2008, and it's an expansion of a principle that was articulated way back in 1999, and the case was Commonwealth versus Gonzalez. You may have heard ADA Lynch mention Gonzalez. And Gonzalez is the classic case from the Supreme Judicial Court that talks about exit orders, meaning when can the police ask me to leave my vehicle because they want to search it? And the basic law of Gonzalez is they cannot ask you to leave the car or search the vehicle unless they have, quote, a reasonable and articulable suspicion of criminal activity. That's a mouthful. Reasonable, articulable suspicion of criminal activity. So, under this fact scenario, did Officer Dickson and Officer Davis have a reasonable and articulable suspicion to ask the occupants of the vehicle to step outside of the car while they searched the car? What do you think? No?
Yes.
Well, it's a close case. It's a close case. Do they have a reasonable suspicion that their safety might be jeopardized in this case because of the threat of weapons being on the person or the persons in the car?
Not safety.
Huh?
Not safety.
Not
A bunch
safety.
of 17 or 18-year-olds.
Well,
If they had a weapon.
certainly 17, 18-year-olds that carry weapons out there for sure, but none of you. But, okay. What about the movement in the car? Does that give him, they use the word furtive. That's another legal, it's not a legal word, but they use it all the time. Furtive meaning, disruptive, it's nervousness, it's activity like this, reaching under the seat or reaching into the glove box. I didn't hear any of that, but I saw the officer testify that he saw movement in the car. I mean, if you've ever been pulled over, usually you're not sitting like this, straight up. You're looking behind to see what's going on. The officer has those takedown lights. They usually aim the light right into the rearview mirror, which then illuminates the whole car. I know none of you have ever seen this before, but you watch TV at night, right? But the idea is that people are nervous to begin with in any police encounter, so the law recognizes this, and there's language in this particular case that says that people are routinely nervous, and that passengers in a routine traffic stop have a reasonable basis to understand that the police are going to approach, but they have to have some justification to order them outside of the car in a routine traffic stop. So that's the first thing I have to do. Go ahead.
Could the movement be getting out of the lights?
What's that?
Could the movement in the car be from getting out of the lights?
Sure. There might be, your eyes might be hurting because the takedown lights, sure, right in their, you should be a defense attorney. There you go, Rob.
I'm gonna make a note of that.
Okay. So, the movement might be totally innocent. It's not necessarily consistent with movements that would suggest that they were trying to stash a weapon under the seat or the drugs, between the seats or whatever else might be there. So the idea behind this, it's called pretextual. Pretextual means an excuse for the police activity, that they are using an excuse to get into the car illegally in violation of the Fourth Amendment to see if there's any incriminating evidence. In this case, of course, there's a bottle of alcohol in the car, and we have minors, so minors in possession of alcohol is criminal activity, and if you're arrested and charged with the crime, then there's this thing called search incident to a lawful arrest, which gives the police wholesale license to take the car
put it on a tow truck, bring it to the yard, they inventory it, all of that stuff. And that's not what happened here, but that's a possible scenario that could come of this. So back to the facts. So I'm trying to look at the facts and say, okay, we have this, quote, supposed justification for the officer to do more than just issue the ticket, as Attorney Hofmann says, and, you know, be on your way type of thing. He can look inside the car with a flashlight or even with their naked eye without any problem, because that's called the plain view doctrine. So if you have incriminating evidence within the purview that anybody can see, the public or a police officer, that's ripe for the police to seize that. There's no problem there. But once they get the passengers out of the car, assuming that the exit order is proper, we have the bulge in the driver's pants, the roll of $400, and then we find, of course, marijuana. Now, this doesn't mean that the end justifies the means by which they can go about this. Just because they did find marijuana in the trunk, and there are plenty of cases out there where the police have seized kilos of cocaine or huge stash of weapons, and the motion to suppress is allowed because they didn't follow the correct procedure that's been outlined under the case law that interprets the Fourth Amendment privilege against being subjected to unreasonable searches and seizures. So this is the classic technicality that you sometimes see in the movies or on TV, dare I even suggest that that's real, that people can, if you will, avoid criminal prosecution because we safeguard our rights to that extent that we will allow a motion to suppress if we feel that there is a constitutional deprivation involved. The same goes with, you know, police interrogating witnesses and the like. So in this particular case, there's an exit order, the passengers are outside, now they find the alcohol. So we have this concept in the law called proportionality. The police can conduct a search in proportion to what's required under the circumstances. Again, this is unique to each and every set of facts. So proportionality is involved here where the police are searching the vehicle, subsequent to finding alcohol in the car, and then they do the driver is field tested, and there's this concept in the law called FIO, field interrogation and observation. So the police are free, because again of the public safety doctrines that are involved, to make sure that the operator of a motor vehicle is operating that motor vehicle safely so that they don't let someone who might be under the influence of alcohol or drugs get back behind the wheel, drive down the street, and head on, you know, wipe me out or anybody else or any of you. So there's a concern about the police not allowing someone who's impaired to continue on their way if in fact they encounter someone on their way. So that's part of their community caretaking function as well. So we have the driver is field tested, he fails the field test, and then he's given a breathalyzer test and he passes it at the police station. Okay, but yes.
I believe actually as a minor isn't .02 failure?
It is, but I'm talking about
Oh, okay.
at the, sorry, junior operator, I'm sorry.
Yeah.
At the stage where the field interrogation and observation is that he fails the he fails the test. The breathalyzer is really not important right now.
Mm-hmm.
It's going to come later in terms of criminal prosecution, but it's not important because the police have made a judgment call at that particular moment in time that the driver's impaired and therefore cannot operate the vehicle. We don't know what happened, but I'm guessing that he wasn't allowed to get back in the car and drive away.
That's true.
The car was probably towed, and folks had to come back and get picked up by their parents or whoever else. So then we have this idea of the notion, because I asked the Commonwealth about this, you heard this thing called joint venture. I'm trying to leave some question time here. We're coming right up on 1 o'clock.
Hmm.
What's joint venture? You know, what do you mean that I'm going to be charged with the same offense as everybody else? Did you hear me mention that? What's joint venture, ADA Lynch? He loves the joint venture. Why do you love joint venture?
Joint venture means that when you have more than one people that can be responsible for one crime, you don't have to figure out who the principal is and who might just be helping. When you have a jury trial, and at the close of the trial, if you have that scenario, the judge will tell the jurors that people could be responsible for the crime if they did something in furtherance of the crime and they shared the intent that the crime be committed. So that can involve being the person that actually put the dope in the back of the car, or it can also be the person that might be driving, you know, understanding that it's back there, trying to protect their friend, and preventing the police from getting back there, or even acting as a lookout, something like that. So just being that type of person, knowing what's there, sharing the intent that the crime be committed, and just doing something in furtherance of it can make you responsible for the crime, just like the guy who actually might have the marijuana on his person. So
Joint
that's
venture is dangerous because it's called participation, ratification, or condonation. Those are the three words. Participation, ratification, condonation, meaning I somehow condone this. I'm part of this thing. And there's a lot of peer pressure involved in this. I don't want to be the person that says, I don't want to be in the car. I think you might have marijuana in the trunk type of person. Why don't you like joint venture, Attorney Hoffman?
For that reason. One thing about joint venture, and I think it's probably more important in this particular scenario to talk about joint venture with the alcohol, because it's pretty clear that everybody probably knew that that bottle of alcohol was in there. In order to be a so-called joint venture, it really just means a participant in a crime that's going, that has occurred or that is going to occur. And what you have to, what the government has to prove in order to convict you of something like that is not only that you were there and that you knew it was going on, but that you wanted it to go on. And I think the knowing it's going on is important in a case where somebody finds some marijuana in the trunk, a locked trunk of a car that doesn't belong to any of the people involved. And I think it's important that everybody understands that in a scenario like this, and I think they say they only charge the driver with the marijuana. But
Yeah, we did.
But
The others with minor possession.
they'd
of
have to,
alcohol.
yeah, and that's why I think the joint venture with the alcohol is a whole different story. The government for joint venture doesn't have to prove that that's the backseat passenger on the left's bottle of vodka. They just have to prove that somebody in that car owned that vodka, and that everybody in the car was involved in having that vodka, and everybody was interested in having that vodka. Basically, if they thought they were going somewhere to drink that vodka all together, they're all guilty. That's the gist of it, I think.
All right, we're coming up on decision-making time now. How many people think that I should allow the motion to suppress, which means that the Constitution was not adhered to by the police, that the government has not fulfilled its burden to show that the evidence was properly seized within the confines of the Fourth Amendment to our United States Constitution? How many people think I should allow the motion to suppress and suppress the evidence, which means it's a victory for the defendants? Let me see if I show hands. Okay. And the rest of you, I'm assuming, say I should deny the motion to suppress, saying that the Constitution was. I know it's a close call, but this is what I get paid for. Go ahead.
I had a little technicality.
Sure.
While the alcohol was in the immediate area where the defendants were sitting,
Backseat.
at the marijuana was in the trunk.
Yeah.
There's been a lot of talks in my government class about there must be some type of specific cause or degree in order to search the trunk. Now, I'm on the fence here in terms of I believe that the marijuana should be dismissed as evidence while the alcohol is fair game.
Okay. Well, that's certainly a possible ruling that I could make, that they have the right to go as far as seizing the alcohol but not opening the trunk. And of course, 88 Lynch is going to argue. Why should I allow the Commonwealth to go forward with the evidence that's in the trunk?
Because as you look at everything that the police do, step by step, you have to justify everything. And once you get to the back seat where you have 5 underage kids with a bottle of booze, now instead of just reasonable suspicion, you have probable cause. You have probable cause to believe that a crime is being committed. That opens up the opportunity for the police to search the whole car, right? So once you get that probable cause, now you have a right under the case law to get into the trunk and look in containers of the trunk. And once you're there lawfully and you come across something else that's not booze, whether it's a gun or marijuana, then that's justified. Since you have the right to be there, you find it, now you see it, you can take it into custody and the person could be charged.
This goes to the issue that I mentioned a moment ago about proportionality. Little baby steps to get them to that level. First starting off, they can't just have a hunch. A lot of times people are under the misunderstanding that police just have a hunch. You know, this person looks like a bad guy or gal. So hunch is not going to do it. It has to be a gradation of reasonable and articulable suspicion that criminal activity is occurring, amounting up to this level of probable cause. If there's probable cause, now they've met that burden of being able to effectuate a lawful search of a motor vehicle because of the fact that the motor vehicles out there on the highways and byways, they don't have time to go back to the, say, excuse us, could you just stay right here? We'll be back in about 2 or 3 hours. We're gonna go get a search warrant over at the courthouse, but don't you folks move. Just stay right here, we'll be back. Not practical.
You have 45 seconds to rule, Judge.
Okay. I'm getting it. All right, any other questions before I do? Yes.
Hofmann, where were you going with the seatbelts thing? Why was that?
He's trying to say that, I'll answer the question for him. He's trying to say that that was normal activity in the back seat, that they were just, you know, either putting their seatbelt on because they didn't want to get a ticket for not wearing a seatbelt, because they can get a ticket for not wearing a seatbelt, or they were taking the seatbelt off.
they were just arranging their seatbelts, and that's what the movement is. He was trying to say that that was normal, reasonable behavior by people who are being stopped. Okay, my ruling is that the motion to suppress should be denied, that the police were acting appropriately with respect to the case law and the Constitution, the Fourth Amendment, that they proportionately follow the prescripts of the Constitution, therefore the evidence comes in at trial.
Hey, the round of applause to our panel. You can give the worksheet in class on Monday. We didn't get, which is fine. Didn't have time to, but just finish it and give it in class on Monday. Thank you very much.
Do we have to do that worksheet too?
No, you don't have to do it.
Yeah, you do.